All right. Today, we're doing a video called How New Cases Work and Don't Get Defaulted. This is the Oregon Family Law Series. My name is Ray Churba. I'm a licensed attorney in the state of Oregon, and I litigate family law cases for the Center for Nonprofit Legal Services. I wanted to make this video because I know a lot of people who find themselves in Oregon family law cases have never had a legal case before. So they really have no understanding of how the court works. And then sometimes I see people get defaulted when they think that they have already appeared in the case and they can't be defaulted. So I just wanted to clarify some basic operations of the court to help people with those issues. Now, this presentation applies to new or prejudgment cases. If a general judgment has been entered into your case, this video is not going to apply. But if you do not have a general judgment that has been entered in your case yet, you should keep watching. So, if you lose your case by default, the other side will be awarded by the court everything they asked for in the petition. A default occurs when a respondent fails to appear in the case by filing a document called a response. And to avoid being defaulted in a case, the respondent must file this document. There is no substitute for filing a response. Okay, so let's take a look at how a traditional case might go when a default occurs. So the petitioner goes down to the court and they file a petition. Then they take that over to the sheriff's station and they have the sheriff serve the respondent. That starts a 30-day period where the respondent has to file a response within those 30 days. If the respondent does not do that and no response is filed on day 31, the petitioner can go down to the court and file a motion order asking the court to find that the respondent is in default. And if no response has been filed, the court will sign that order and declare the respondent in default. And once that happens, the petitioner can submit a general judgment, which gives them everything they asked for in the petition. The court will sign it, and that resolves the case. So we can, excuse me, we can contrast this to how a case goes, a simple case, when a response is filed. So same thing, petition gets filed, 30 days for respondent to file a response. Let's say they file a response on day 27. The fact that a response has been filed tells the court, hey, we need to set a trial in this matter. The respondent has filed their response, so they're in the case. The petitioner filed their petition, so they're in the case. So everybody's here, so let's get a trial set. Now, one question I frequently get is, how long is it from the time that the response is filed until when the trial occurs? And that just depends on when the court sets the trial for. And there's really no there's just no telling. I have seen trials get set for 3 weeks after the response is filed, and I have seen trials get set for 18 months after the response gets filed. It depends on how busy the judge is, whatever, there's just no telling. But this is the progression of a simple case when a response gets filed. So why are people getting confused and getting defaulted in cases when they think they have responded already? And the reason has to do with the period of time represented by the blue bar, the 30-day response period that the respondent has. The reason is that things can happen in that 30-day period. And usually what happens in a family law case is mediation or a hearing. The petitioner sets mediation or the petitioner sets a hearing to occur within the 30-day response time. Now, a moment ago, I just told you that a trial doesn't occur until after the response has been filed. So you might be asking, how can a hearing occur before the response is even due? And to understand that, you need to know that Oregon allows pretrial hearings in family law cases. And this is because these cases can take a long time to resolve. And so Sometimes it's not fair to make somebody wait all the way until the trial for certain kinds of relief that they want. So if you look, this is the statute ORS 107.095 A through G here. These are all the things the court can order after the petition has been filed and before the general judgment has been entered. So let's take a look at the differences between a trial and a pretrial hearing. And the biggest differences are that a trial resolves the whole case. The judge will consider the petition, the response, everything in the case, and resolve all the issues. A pretrial hearing only occurs when one party files a motion asking for that hearing, and the issues addressed in the pretrial hearing are limited to the issues that are raised in the motion that requested the pretrial hearing. A trial results in a general judgment because all issues are resolved, and a pretrial hearing results in what's called a limited judgment because the order is limited to whatever issues were raised in the motion. Now, issues commonly addressed at pretrial hearings include parenting time, child support, status quo orders, and exclusive use of residence or property. If you don't know what a status quo order is, I would strongly suggest that you look at my video on status quo orders. Um, Status quo orders can really save you a lot of time. You have a short window to get one, but I see a lot of people struggle to get custody hearings when all they really need is a status quo order. So take a look at that and save yourself some headaches down the road. Now, how does this work in the real world? How are people getting defaulted when they think they have appeared in the case? And so, what's happening is the petitioner goes down to the court, files the petition, and the two biggest reasons, in my experience, that petitions get filed are one, the petitioner is not getting child support from the respondent and they want to get child support, or the petitioner is not the child is being withheld from the petitioner. The respondent has the child and won't let the petitioner see it, so the petitioner comes down and files a petition. Now, let's just say that the petitioner maybe has talked to a lawyer or has some sophistication and they understand, hey, I'm coming down to file a divorce or a custody petition, but I know that if the respondent comes in, hires a lawyer, and contests everything, my trial might not occur for a year or more. And I don't want to wait that long to see my child or to get child support. So when the petitioner goes to the court and they file the petition, maybe they also file for a pretrial hearing on the issue of child support or on the issue of parenting time. And maybe they set that hearing within the respondent's 30-day response time. That can happen. So, so then when the respondent gets served with the petition, they also get served with a notice of a pretrial hearing. And maybe that hearing is happening on day 20 of their response period. So this hearing is happening before their response is even due. And frequently, what will happen is the respondent will come to court for this hearing on child support or parenting time, whatever it is. And then the respondent thinks, okay, well, the court knows I'm in the case. I went to court, I did a hearing, I sat there across from the judge, I was part of the hearing. They know I'm in the case. And that is 100% wrong. The court has over 1,000 active cases. The court has so many cases. They don't know if you're coming to court for a hearing or for mediation before your response is due. They don't know that. All the court knows is that your response is due 30 days from when you were served. And if you don't file a response, then as far as the court is concerned, you're in default because no response has been filed. And if you don't file your response within 30 days, the court will actually send a notice to the petitioner and they'll say, hey, move your case along. The respondents had 30 days, no response has been filed. We'll dismiss your case if you don't move your case along because the court doesn't want inactive cases just sitting around. They want their cases worked, they want their cases resolved. So they will pressure the petitioner to find you in default. So So don't be confused. Don't believe that just because you went to court for a hearing during your response time, you don't need to file that response. You do. You have to file that response, and so get your response filed and avoid the default. Okay, so that's pretty much what we have for you in this video. I do have a couple of final thoughts here. Um, Obviously, you have to file your response. If you can't afford the response fee at the court, ask the court about a fee waiver. If you need a pretrial hearing, set one up. Use a status quo order if you need one to save yourself some headaches down the road. And the last thing I'd like you to know is that Oregon Circuit Courts have a really great text message system where they notify unrepresented people about events in their case. And you can sign up for that system even before you file your response. So, regardless, if you're the petitioner, make sure you're on there. If you're the respondent, make sure you're on there. You can just give the court a call, tell them, hey, this is my case number. Here's my cell number. Can you please put me in a text message system? And you can get your notes or your notices by okay. So that's what we have for you. Thank you for watching. Good luck in your case, and I will see you in court.